You need to be aware of this. When you get a final order, you go through the final hearing and the judge makes a final order. In most states, that final order is not automatically entered, is it? And a lot of parents don't realize you are not done paying for attorneys. You are not done working on fighting over that final order. So even though the judge might have said, this is my ruling, this is what you get, this is what she gets, you'd be amazed at how many parents still lose even more after the final, or run out of money and can't get the final order entered the way the judge ruled on it. So I don't think most people are telling you guys this, but you need to start preparing for that right now. And there's several things, several steps that you need to be aware of, but one of them is that you need to get at the very end of your hearing, the judge renders their order, and hopefully you have a court reporter and it's on a transcript. You need to get the end of that transcript before that order is entered. Okay, that's going to save you a lot of money. Otherwise, the other side is going to try to convince you, oh, no, judge didn't say this. You got that, not this. And when that order gets entered, it doesn't mean that you can't go back and fight it and say, oh, that's not what the judge ordered, but guess what? That's even harder. It's more money, waiting, more time, delays, all kinds of stuff. The other thing is if it gets entered and that's not what the judge ordered, then there are several things that you can do to try to get more yourself. As well as before that order's entered, you can start preparing to get more if justice wasn't really delivered, okay? So it's not the end at the final. Now, how many of you are in modification right now? Like I saw you shake your head. You're not in modification. It's your initial proceedings, right? The first time. Okay, I can't hear you. Click on the unmute. Do you see it at the top? It should be at the top of your screen. And okay, there you go. I can hear you.
Is this better?
That's much better. Yes.
Basically, I've been in court twice. The first time I was in court, it was to order show cause.
Yeah. Yeah.
Prior to that, almost 6 months, I didn't. They have done a couple courts and hearings supposedly, and my ex-wife to be, she got an order of protection, and she placed in divorce, everything. And every time I was going over there, I was never heard. I never saw a judge. So I saw an actual judge after 6 months and a half, actually.
Was it a judge or a magistrate?
No, it was a judge. I never seen a face of any magistrate or anybody else. The reason why they used to keep me separate, because she placed an ex parte order.
Right.
So they used to keep us separate, and all I saw is my first lawyer coming and going. The second time, my second lawyer coming and going.
Yeah.
And then the third time, actually, these guys did something better. So now where I am, it's in modification or a temporary order, and we have started the trial. So we had 1 day of the trial.
Okay, was that just recently?
Yeah, it was actually in February. February 6th was the order, or the day that we were in the first time in court, and the trial started on the 20th March, which was like a week ago.
A week ago. Okay, explain to everyone else, because they may not understand this, but I believe in New York, if you're in an area where they do this, don't they appoint an attorney for you?
Actually, they do if you don't have the resources.
Right.
Have money to do that to you, but that was not the case.
Okay. So you're paying for your legal assistance right now, then, right?
Everything, yeah. And I've changed 3 lawyers, and the bill is going sky high. It's like 37, and they sent me another bill for 30 something now, 3,400.
3,400. And how long has this been going on for you?
It's been going for 8 months now. Maybe
8 months.
9.
Okay, so not very long. Do you think you've spent over 15,000 at this point?
Just for the divorce and the child custody and yeah, there's just those two. I've spent 28,000.
Right. Okay. Wow. Okay. Well, and just so you know, in one section of mine, at one point, I think it was less than 2 months, my bill was up over 15,000 when I went through. It all depends on what they decide to do initially. A lot of times they'll hit you real hard at the beginning because they'll want to do all kinds of discovery. In your case, unfortunately, you were hit with the notorious protective order. It happens to a lot of guys. Okay.
Yeah.
I haven't heard it happening to as many women, but there are some women that have come to us that this is happening as well. Um, that's the fastest way they gain advantage, right? But let me mention something. When you're going through that, I'm assuming that the protective order is filed after you had some kind of separation, or you two separated.
No, what happened is that she wanted a divorce, and in the same time she was saying, no, we're gonna work it.
Okay.
Then she wanted me to find another job. I went and find a job. Then I'm coming from training from Chicago. Then she
Okay.
have picked up everything. She have looked for a new daycare. She have looked for a new apartment. Uh,
Okay.
so it was my day off. She called the police. She said that I'm taking the child away from her.
Okay.
Uh,
So
it,
so
so
so it's
what happened is that she filed. I was served with a divorce at home.
right.
Uh, a day prior to she leaving the house actually. So she didn't show up. She showed up later. She left again. Then 2 days later or 3 days later, when after I already went the same day at the lawyer, I was served with divorce. She already had applied for ex parte. Uh, then
Okay,
two days
but that's
later,
yeah, that's what I meant is that they serve it when they separate or they file for divorce, right? The
yeah,
protective order. Okay. So what we've discovered that you need to bring up to your attorney is there is a doctrine, I don't recall the name of it, so I have to look that up. But the concept behind it is that no new conditions can be created during the pendency of the child custody battle or the divorce. I'm not
yeah.
saying
New
new
conditions.
evidence. Hmm?
Can you send me the link so I can?
Yeah, I gotta look up the
Not
doctrine,
right
but I'll
now. Not
send you.
right now. You know, I don't. I
Yeah.
know I'm taking everybody's time.
No, I think that's what everyone's here for. I mean, you guys okay? We're holding this discussion, so the question, what I'm bringing up right now, what is this? Um, is something that all of you need to be aware of, and that is one side gains advantage by creating drama,
Yeah.
inflaming the court. When they do this, the other thing that they start to do is they alienate your child from you. They are creating conditions that did not exist before the filing of the divorce. When they create these conditions, you have to plead to the court to not allow them to use conditions that they create. Okay, but that doesn't mean they can't enter evidence to try to prove you're guilty of something. That means that they cannot use evidence they created.
Yeah.
So I hope that makes sense to you guys. If it doesn't, you need to send me an email so I can discuss it with you separately,
No,
okay?
even for the things that she got, she was even lying on the documents. Like what
Yeah.
I'm saying, lying, actual like date that she was putting and stuff that she was putting. She was not even at home. You know what I'm saying? Like I was not even at home. You know, like so. If they bring this up, I'll be more than happy to go with it. You know?
Okay, the lying is separate. Okay, the lying is where you will have your attorney, and the attorneys know how to do this part. They will try to prove to the court that they don't have good character
Yeah.
so that the court won't believe them.
Yeah.
Okay, so anything that they say after that, it's pretty much like the court's like, whatever. It's a he said, she said, and your attorney tries to get the court to trust and believe you more. So that yeah, so the lying is a problem. Now, if you're able to prove something in a lie that has caused you damage, there are laws in a lot of states regarding that, but most parents fail at actually getting those laws used. They fail at convincing the family court judge to use anything that happens in the course of the divorce,
Yeah.
even if they're lying about you, because They try to make you think this is just about your child and property
Yeah.
division.
Yeah.
They don't care about all that. They assume
Yes.
both sides are going to lie. The problem is when they use those lies to punish you. Okay, when they use those lies to justify ordering a protective order, when the court uses those lies, that's a problem. But here's how they use the lies is if you open up to the court that you are asking them to choose between you and the mom, or the mom's asking them to choose between her and you,
Yes.
then you're giving the court,
The authority.
yeah, the authority, you got that, the authority and the ability then to provide you with what you're asking for. And if they don't side with you, you don't get to go to appeal court and relitigate it. Too bad. You had your opportunity to convince them. That's why you don't want to do that. No matter
I haven't done it
how,
though.
yeah, I'm sure you didn't. It's usually the parents we get here are the ones that are being attacked. They are the ones generally that believed that the courts would never believe their lies, right? They believed that they could just have an attorney protect them and they would be fine, and that they would walk away with a fair ruling. When that doesn't happen, you're already behind the eight ball. And you're already going broke, because the third thing that they do, so first they go for the protective order. Second, they use conditions they create during the pendency of the divorce and child custody battle. And then third, they put a bunch of expensive burdens in place to run you out of money so that you can't protect yourself anymore or defend yourself anymore. And then what happens is one of you, usually the person that runs out of money, has to give in. Okay?
I'm hoping
So
she
they're
will be the
using
one.
very, what's that?
I'm hoping she will be the one at this point.
Well, yeah,
So,
but that's not a very good strategy to
oh, I
use.
know. You know, you can pay
And
for the college for the kid.
yeah, I know you don't want to use that strategy, but they're not giving you a whole lot of options. Okay, so we're going to change that. We're going to give you some other options you can take to your attorney. I did work with some parents in New York. Their attorneys were appointed. They had me on the phone with their attorney, and I would help explain different parts of the strategy that they could insert into the strategy they're using for you right now. And that helped them. Actually, one of them ended up having to withdraw their case because they were going to be held in contempt for something. So sometimes the solution is as simple as that. Now, in your case, she filed, so you can't withdraw. Okay, so she filed, so you have to go about this a different way. So let me move on to another question here, and I think it's going to give you some more information too. So I want to make sure I get to some other people, but write those three things down because I want to email that to you, and that's creating conditions.
Yeah, I wrote that.
Yeah, creating conditions, and then also preventing costly burdens. And so what you need on that is you need how to shift the burden of proof onto her. Because if she's lying and getting away with it right now,
Yeah.
her burden of proof hasn't been raised on her. They're using the lowered preponderance of evidence standards.
Yeah, that's what a person told me. You know, all
Mhm.
this is gonna come to the court if she's saying that she's have to. But what they've been doing right now, they're saying, oh, you got only the problem, the money and the custody, like you said. So they're not bringing up how we are in this situation,
What do you mean how we are?
where she got full custody in first place. They were giving me 15 hours. I haven't seen any judge, or it was, you know, then
Okay,
up
so
to the,
so you're talking about due process violations. And
yes,
note that down, okay? There's different ways we go about it. We don't just have you file complaints or grievances about due process. What we do is we have you start presenting to the court different, you use some different arguments in the court that requires them to increase the protections that they're using. So in other words, we show you how to implement that proper due process and guide that judge. So you have to guide that judge. If the attorney's just letting the judge run everything
yes,
and take over,
yeah,
then you're going to get the same bad results. And once they've picked one side, if you keep going down that path, you're going to keep getting those same results. So your attorney needs to learn how to ask the judge and how to present the judge with the proper solution. Okay? And some of them are scared to do that, but when they get a little bit of our help, they become much more comfortable with it.
Yeah, they're up to you. The same thing I had 18 minutes ago before we were waiting on this.
Mhm.
I told my lawyer if I can place a motion regarding adjusting my the money, the child support. Why I cannot place a motion regarding seeing the child on a weekend?
Yeah.
And they tell
Uh,
me, oh, you don't want to piss him off, you don't want to do this, you don't want to do this. I'm like, it's my child, It's
yeah.
same as it's hers. It's
Yeah.
mine. Why I cannot do that? Oh, but he's busy, he's doing this, he's doing that. Yeah, but this is my case. If you cannot be able to, and then she goes to me, oh, I'm not gonna do it. Like just how I'm saying, like I'm not gonna do it. She goes, I'm like, okay.
Then why are
I
you
hope your
paying
day
that?
gets better.
Why are you paying that attorney? At least they're letting you know. You
Um,
know. Uh,
I don't
I
want to, I don't want to be without an attorney because this is my third lawyer.
yeah.
And every time I go to the court, even for a piece of paperwork, when I wanted to like transcript and what
I'm
she
not
said
saying.
that yeah,
Yeah.
they
I'm
didn't
not
have
saying.
anything.
I'm not
And
saying go without an attorney. I'm saying these are things you need to ask the attorney if they're willing to do for you. And when they say no, they're not, and you continue to use them, you're basically giving in then.
I'm giving in because there is no other person around here, and I mean this, that will go along with what I need in order to do the right thing.
Are they
Because
telling you
everybody
why?
that I meet, they want the money first, and they tell you what they're gonna do for you,
Yeah.
without even that you have on your head. Okay, I got this, I got that, I got that, and I need this, and I need that, and I need that.
Yeah.
And they are like, okay, no, you can't do that. No, you can't do that.
Well, that's a common problem again, and then you have to decide because you're right. You can't force them to do what you want, and some of them will tell you it's not going to. The judge isn't going to agree with you, right? So they're
Yes.
afraid. They're afraid of you getting a bad result by pushing for what you want, and what you're pushing for may absolutely be your right. Like you said, it's your child, right? If there's no direct danger you cause to your child and you're not unfit, there's really no reason they should be in there restricting you more than restricting the mom. So
Yep.
you know this, but they also know that's not the way the judges do it, but it's also not the way they're asking the judges to do it. And they're telling you they're not willing to change that. And a lot of times I get feedback from attorneys who aren't willing to do this, and they say, you know why? I don't like to lose. But I tell them, but the children are losing when you don't do this. They're losing. But the way they look at it is, hey, sometimes we convince the judge to side with us, so I'm okay with that. But I told them, but then they lost that other parent. You still didn't win. But they don't care.
Yeah.
When they don't care, you cannot force them. If you don't want to do it on your own, which I don't blame you, okay? So it doesn't mean we're going to stop giving you information or stop helping you. You may be able to do some of this through your testimony once you get a chance to be heard. You may be able to do some of this yourself, okay, while having an attorney, and that's a discussion we can have as well. So you may not be able to get as much in there, but you might be able to get a little more, okay? When an attorney is absolutely refusing to do these things, though, and you have to, you have to use them because that's all you're comfortable with, then you might have to be okay with what they do, and your only other alternative is then to get active with legislative process and get those laws changed, because the judges, a lot of times they're dealing with judges who are strict constructionists, and they only are willing to do what's in the statute. Even though they can challenge the statute themselves, they can say this is not going to be constitutionally applied. I won't get a just result with this statute, so I'm going to suspend this statute in this case. They can do that. They're the judge. A lot of them don't do that because that still ends up challenged by the other side, right? Judge didn't follow statute, and then the appellate court could end up siding against them, so you still end up with a long fight like that, and the judges know it. Unfortunately, though, for these judges that are stripping children of their rights to be with both parents, parents are getting smart now, and they're ending up with a long fight anyways. So when you present them with the proper solutions, you'll actually be, judges who take control will start asking you during the hearing, okay, So you're wanting the equal time. You're wanting this. You're wanting that. You know, because I'm assuming your attorney will still ask for that. Okay. They may ask you then, how does that solve the problem, right? How does that solve you two fighting? And you have to be prepared to give them a solution that they can actually do, that they are comfortable with. So that's where you convince them with what you learn here. That's where you get opportunity. And I've seen this happen in so many cases. Almost every case that we've helped on, the judge at some point turns and asks the witnesses questions themselves. Okay, so you have to be ready for that. You don't really want them taking over from your attorney because you're paying your attorney to protect you. But if they are willing to hear your solution, that's perfect opportunity. I've seen some parents blow that opportunity because they didn't prepare. They didn't know what to give them. So we'll remind me to discuss that in a few minutes. I see a lot of people responding. One person says they had 6 lawyers that never did anything. Well, one thing you have to remember, what did you ask them to do? And then what did you provide them with to help them do that? And I know a lot of you might say, but it's my lawyer, I'm paying them, they should know how to do this. If they don't, you're going to have to help them. I agree, they should know how to do this, but they don't. So you need to provide them with the tools to do it. Some of them refuse because you don't provide them with the tools. The other reason, what did we discuss? The other reason is they don't perceive doing that as winning. They don't understand that if you put this on the record properly, you have more opportunity to challenge it in the appeal court. Yes, that takes time. In some states, it takes 2 years. I've seen it take 2 years here in Texas. But how many years, maybe not you yet, but some of these other parents, how many years have you already been fighting? I know Rustin, who's helping with our legislative process right now, has been fighting over 10 years. What would 2 years have done? And how would that have made a difference if he had actually put on the record all of these things that preserved his opportunity to have the appellate courts actually visit whether or not it was constitutional? That would have been way more powerful. It would have changed the game. But a lot of people think, and attorneys, this is going to make it more difficult. Like I said, you're going to piss your judge off. Okay, well, so far, with every parent we've worked with that has followed these materials without implementing other stuff, like there's other methods that some people try to combine with our methods, and so I can't be responsible if you piss the judge off with that. But the ones that have stuck strictly to the methods that we got from the Supreme Court materials, so when they say you're going to piss the judge off, when you leave the judge guessing about why you're doing what you're doing, when you leave them guessing or believing that challenging the court's idea of what's best for your child is just you being difficult, if you leave them with that idea or you don't address it, like addressing the elephant in the room, then yes, the judge will be upset because you're asking the judge to do something they're not used to, and then you're not providing them with the proper authority or the tools to do it. So you just frustrated them. So the attorneys are telling you, I don't know how to give this to the judge without frustrating them. Okay, well, you can talk to them and overcome that.